My name is Warren Brookbanks. I'm a professor here at the law school and I'm standing in for our Dean, Professor Andrew Stockley, who sends his warm regards to you and to Catherine. He can't be here because he's overseas at the moment, so I'm standing in for him. But it's our great pleasure to welcome you here tonight. It's good to see a nice crowd at 6 o'clock on a Tuesday evening. And I'm sure we're going to be in for a real treat as Catherine speaks to us. I'll just give you a very brief bio of Catherine because it's quite interesting and it's important that you know who she is and where she's from. She is a magistrate, but we call her judge. She's a magistrate from Perth, where she's based in the Children's Court. She's worked previously as a magistrate in the Magistrates Court of Western Australia, and for 2 years between 2008 and 2010 she was the resident magistrate in the East Kimberley. Now she may well want to explain what or where the East Kimberley is, but it's somewhere over there. And in that capacity she has dealt with adults and children in various regional towns and with Aboriginal communities as well. Her particular interest and the reason that she's come here is to pursue her interest in and to lecture on fetal alcohol spectrum disorder as it affects young people who appear in court and the impacts, particularly the adverse impacts that has on individuals, families and communities, especially while it's undiagnosed and without appropriate support and targeted services. Judge Crawford believes, as a matter of justice and to facilitate community protection, that courts need to be enabled to factor fetal alcohol syndrome disorder as a disability and impairment and take it into account when dealing with youth and in sentencing in order to properly reflect issues of culpability and capacity in individuals. And I think it's a very important topic which has in relatively recent years begun to come to the surface in New Zealand, and I think there's a growing awareness, so we really are indebted to Judge Crawford to be here to talk to us tonight. She's here on a Churchill Fellowship and this is the tail end of a 3-month odyssey where she's travelled to a number of other countries in the world, and we're very lucky that she's been able to come and to be with us tonight. So could you please join in welcoming Judge Crawford.
Thank you for coming out this evening. Firstly, could I thank Professor Brookbanks for the kind welcome this evening, and also for making this opportunity available. And that was very generous, thank you. As he said, I'm at the tail end of travelling around talking to people about how young people affected by fetal alcohol spectrum disorder and involved in the criminal justice system are being dealt with in various places. I feel inadequate to the task of talking to you about that issue today, in the sense that I've made a lot of observations, I've acquired an awful lot of material from an awful lot of different people, and of course I'm yet to properly digest it, process it and write a report, which I'll be doing very shortly. But this is a wonderful opportunity to be able to share with you some of my observations about programs that appear to be working in some places, and put that in a human rights context. Now, before I get to that, can I just firstly acknowledge and thank Christine Rogan from Alcohol Healthwatch for organising this event this evening. My perception in watching from afar things unfold to some extent in New Zealand is that she and that organisation have been quite a leader in trying to educate and promote the importance of the issue in this community. I also wanted to acknowledge and thank Valerie McGinn for assisting me when I first became interested in this issue to better understand the implications of it for young people and some of the options available when it comes to assessment and diagnosis. Now, my visit to New Zealand is part of the project, and in other words, that means I perceive that New Zealand is well ahead of Australia in the practical response to the challenge that FASD presents to our communities. And I've come here to learn what's happening here and see what might be applicable in Australia. Now, after making a few more preliminary remarks, I propose to lay the groundwork by briefly recapping what FASD is and the challenge that it poses for the criminal justice system. And then I propose to identify just a few of the obligations on states which are created by several international human rights instruments as a frame of reference for the conversation about how communities should respond to fetal alcohol spectrum disorder as it affects a young person in the criminal justice system, a disability that so often is invisible. As I've travelled from Vancouver to Ottawa, to Whitehorse in the Yukon and various points in between, and in the US, had an opportunity to visit Washington DC, New Orleans and Minneapolis, St Paul, I can tell you that there is much variation. There are some high points where communities have raced ahead with diagnosis and intervention, but in others, not much is happening, or at least not much in the justice space. Now, my project has not been concerned with prevention, but lest you think I don't think that's important, I actually think it's an extremely important objective, but from where I sit, I'm not concerned so much with prevention as with the youth who've suffered brain damage in the form of fetal alcohol spectrum disorder and are involved in the criminal justice system. They are at risk of injustice if the court is not aware of the disability and fails to take it into account when sentencing. There is a high risk of further offending unless suitable and appropriate intervention is put in place for that young person. That is imperative to improve the life outcomes of the individual youth, their family, and to improve community safety. The failure to diagnose fetal alcohol spectrum disorder in a young person affected by it, who's involved in the criminal justice system, causes injustice to the individual and exposes the family and community to a repetition of the unlawful behaviour and indeed likely escalation of the offending as the young person grows physically, suffers secondary disabilities, and those dealing with the young person are unable to handle the behaviours. Now, as a matter of justice and to facilitate community protection, courts need to be enabled to take fetal alcohol spectrum disorder as a disability impairment into account when dealing with the youth, and sentences need to reflect the culpability of the individual and the capacity of the particular individual in the context of the need for community safety. Now, In late 2013, there was a conference in Edmonton, Alberta, Canada, which adopted an unusual process. It was a juried process where various experts in aspects of fetal alcohol spectrum disorder, drawn from a wide range of disciplines, in effect gave evidence to a jury chaired by a retired Supreme Court judge, Judge Binney, and after 3 days of hearing this evidence from a large number of experts, they then proceeded to draft a consensus statement on legal issues relating to fetal alcohol spectrum disorder. I would highly recommend that document to anyone who is serious about coming to grips with fetal alcohol spectrum disorder and the challenges it presents in the legal system. Just to briefly set the scene for what I want to talk about in a few minutes, I want to just recap on a couple of points that are set out in that consensus statement. Firstly, it provides a useful summary of the nature of the disorder. It states that FASD refers to a range of physical, neurodevelopmental and behavioural impairments resulting from damage to the brain of the fetus caused by maternal alcohol use during pregnancy. The impairments may include growth retardation, malformations of the face, neurological disorders, and deficiencies such as problems with memory, learning, attention, and social communication. The facial abnormalities are not always present, and therefore FASD is frequently invisible and undiagnosed. The brain trauma that alcohol causes in the fetus is irreparable, lifelong, and devastating for the individual, the family, and other caregivers. Now, the consensus statement goes on to neatly describe the challenge that FASD poses to the legal system in terms of the fundamental assumptions which the legal system makes about the behaviour of individuals. And it states, the neurodevelopmental deficits associated with FASD present a fundamental challenge to the Canadian criminal justice system, which is premised on assumptions that people act in a voluntary manner that is determined by free will, that they can make informed and voluntary choices with respect to both the exercise of their rights and the decision to commit crimes. It's presumed that a person intends the natural consequences of his or her actions, and that, for example, an individual would never make a statement against his or her interest unless it was either true or coerced. The jury went on to say that the evidence that they had heard was compelling, that those with FASD are likely to have a diminished capacity to foresee consequences, make reasoned choices, or learn from their mistakes. Therefore, their actions are likely to clash with assumptions about human behaviour at almost every stage of the justice system. And individuals with FASD are more likely to be involved in the legal system than individuals without FASD. It went on to note that children with FASD are overrepresented in the foster care and group care systems, and their special needs and developmental issues have been identified by the courts in all aspects of the law, from criminal prosecutions to guardianship, family violence and child protection applications. Now, it's important for us to remember that FASD represents a broad spectrum of symptoms of greatly varied severity, giving rise to a range of disorders, disabilities, and consequently varying degrees of diminished responsibility and capacity. And the consensus statement went on to note that the elements of neurological damage associated with FASD are well established. However, their expression and intensity vary from one individual to another. Now, it went on to note that FASD-affected individuals are vulnerable to secondary disabilities. It stated, as a result of permanent brain damage and other factors, a person with FASD is vulnerable to secondary disabilities and adverse impacts. These include leaving school, family and placement breakdown, homelessness, alcohol and drug abuse and related infectious diseases. Many youth with FASD have been taken into care and are being raised by foster families or group homes, often with several failed placements and possibly inadequately trained caregivers. And it noted that these populations may overlap with a disproportionate apprehension of Aboriginal children in the child welfare system. Unemployment, mental illness and involvement with the criminal justice system are common. And it went on to note that the evidence was that a majority, about 60% of individuals with FASD, come into conflict with the law. So, having set the scene about the nature, to some extent in a summary way, the nature of the disability and the challenge that it poses to the criminal justice system, I note in the West Australian context that youth justice legislation has various objects which no doubt are similar to relevant youth justice legislation here, and that is that rehabilitation of the young person is a prime objective if the young person enters the criminal justice system. Secondly, that there be punishment of the young person. A third objective is to facilitate the growth and development of a responsible member of the community. Now, as important as domestic legal and policy frameworks are in framing this discussion, I think we can gain greater insight into our obligations as communities towards young people with fetal alcohol spectrum disorder if we look to standards which are set in international human rights instruments. Now, I don't aim to be exhaustive here, but I will identify a couple of instruments and some of the obligations established in their provisions. So if we start with the Rights of the Child Convention, for example, arguably there's a number of provisions which are relevant. However, I'll just point to the following, which may be the more pertinent. So Article 23 is to the effect that children who have any kind of disability should receive special care and support so they can live a full and independent life. Article 29 is to the effect that education should develop each child's personality and talents to the full. Article 36, children should be protected from any activities that could harm their development. Now, just to digress on that particular obligation for a moment, arguably a youth affected by FASD, who the literature suggests is more vulnerable to exploitation and victimisation, is likely to suffer mental health issues, as well as various other challenges. So all of that emerges from the research and the literature. To place such a young person side by side in a youth detention facility, or once they've turned 18, in an adult prison environment, when they are likely to have a developmental age much younger, is entirely inconsistent with the obligation to protect them from harm. So if I keep going just to identify a couple of more obligations in the Rights of the Child Convention, Article 37 is to the effect that children who break the law should not be treated cruelly. Now, arguably, to place a young person affected by FASD, that is a brain impairment and a disability, in a detention environment, or fail to treat them in a manner which is appropriate to their developmental age, is cruel. Article 40, children who are accused of breaking the law should receive legal help. and it goes on to talk about prison sentences for children should only be used for the most serious offences. Now, I'll turn to the Convention on the Rights of People with Disabilities. It starts out, and I'm here being selective because of course you don't have the instrument in front of you and it's hard to digest this orally, but it starts out as these conventions often do with a number of paragraphs that recognise certain facts or their statements of principle. So in this convention, one of those is recognising also that discrimination against any person on the basis of disability is a violation of the inherent dignity and worth of the human person. Further on, recognising further the diversity of persons with disabilities. That's particularly pertinent to this type of disability, given there's such a wide range of impairment. It goes on, this Convention on the Rights of People with Disabilities. Article 3 sets out a number of general principles. I'm just going to identify a few for the purposes of this discussion. So the principles of the Convention shall be respect for the inherent dignity, individual autonomy, including the freedom to make one's own choices and independence of persons. Another principle is non-discrimination. Another principle is full and effective participation and inclusion in society. Another is respect for difference and the acceptance of persons with disabilities as part of human diversity and humanity. It goes on to, another principle is equality of opportunity, accessibility, respect for the evolving capacities of children with disabilities, and respect for the right of children with disabilities to preserve their identities. And it goes on in Article 3 to impose upon states that ratify the Convention the obligation to promote the training of professionals and staff working with persons with disabilities in the rights recognised in this Convention, so as better to provide the assistance and services which are guaranteed by those rights. It goes on in a further paragraph of Article 3 to refer to states having an obligation to closely consult with and actively involve persons with disabilities, including children with disabilities, through their representative organisations. Now, arguably, that in the FASD area might be used to persuade government that in the development of any strategy or plan for dealing with the issue of FASD, that the voice of those affected and their carers and circle of support needs to be a very important part of the development of any such strategy. Now, this Convention on the Rights of People with Disabilities goes on at Article 5 to refer to equality and non-discrimination, recognising that all persons are equal before and under the law and entitled without any discrimination to the equal protection and equal benefit of the law. It goes on to create an obligation on states that ratify the Convention to prohibit all discrimination on the basis of disability and guarantee to persons with disabilities equal and effective legal protection against discrimination on all grounds. And states are required, in order to promote that equality and eliminate discrimination, to take all appropriate steps to ensure that reasonable accommodation for the disability is provided. Article 7, which is entitled Children with Disabilities, imposes upon state parties the obligation to take all necessary measures to ensure the full enjoyment by children with disabilities of all human rights and fundamental freedoms on an equal basis with other children. Now think about that in the context of education, where, in my experience, children with various behavioural, neurodevelopmental issues often are failing from quite a young age in the education system, and often the outcome is exclusion rather than accommodation, rather than working with the child and the carer and various support services to modify the education program to accommodate for the particular challenges and impairments that young person suffers. And Article 7, which is concerned with children with disabilities, goes on to require that states ensure that in all actions concerning children with disabilities, the best interests of the child shall be the primary consideration. And also part of that particular article is the obligation on state parties to ensure that children with disabilities have the right to express their views freely, for their views to be given due weight in accordance with their age and maturity on an equal basis with other children, and to be provided with disability and age-appropriate assistance to realise that right. Of course, one of the issues here is the chronological age might be 15, 18, whatever, but the developmental age may be a lot younger. In any event, with that frame of reference in mind, how have other communities responded to fetal alcohol spectrum disorder as it affects youth in the criminal justice system? So I propose to give you a few examples now of programs or projects that I've observed or been exposed to, and then I'm going to talk about a few broad themes and perhaps finish up with a few questions that try to turn those statements of obligations into questions that those of us who are interested in there being appropriate intervention and care for young people affected by FASD might reflect upon and utilise in any advocacy or future action. Okay, so in several places in North America, such as Lethbridge, Alberta, Winnipeg in Manitoba and Hennepin County in Minneapolis, St Paul, programs which are aimed at identifying and diverting FASD-affected youth involved in the criminal justice system have been in place either for a fixed period, usually a pilot project, something like 3 years, or in the case of Lethbridge, it's now been in place for 10 years. Now, my apologies to those who came to the presentation this morning, because the examples I'm going to give are largely the examples that I gave this morning. However, so Lethbridge have a youth justice program. It's emerged from an FASD network established in the community with various other government agencies and non-government agencies who've come together to focus on FASD and how do they address the issues for youth and adults through the lifespan. One of the outcomes of that was to set up this youth justice project. It involved, in collaboration with the local police force, that an experienced police officer was designated as the FASD police officer. And that police officer, they've had 3, I think, in the course of 10 years, had the responsibility of receiving referrals, which might come from education, they might come from police officers, who've had some interaction with a young person and either have charged them with some offence or offences or proposed to charge them. And the FASD police officer will then look into the situation, consult the family, any services in the community, might be consulting the school, find out whether the young person's been assessed for FASD. If not, see whether that can be organised and given priority. Link with another program in the community, the FASD Key Worker program, to see whether the family's got some support, whether there needs to be negotiation with the school about the school program. It might be that the child can't cope, so they're dropping out. So there needs to be negotiation with the school to accommodate the young person's challenges, limitations. It might be there needs to be some external day program. So the FASD police officer is really the point of contact in the police department for seeing whether there is some possibility, firstly of diagnosing if there's no diagnosis, so it's clear for everyone whether there is a diagnosis, what that really means in terms of the capacity of the young person. And then trying to get them linked with the relevant services in the community so that they can be diverted from the criminal justice program. Now, the particular police officer who has this role at the moment told me that there are occasions when she negotiates with the charging police officer and is able, having assembled some evidence, having made contact with various agencies in the community and perhaps having developed a plan in conjunction with those, she's been able to get the charging police officer not to proceed with the charge, to have the young person diverted into some program in the community or have the charge dropped. Of course, that doesn't happen in every case, nor would it be necessarily appropriate in every case. The police service have a system of flagging an FASD affected person in the police database. Now, I acknowledge there are privacy issues about that, but for the moment I'm going to sidestep those. It's done with the permission only, with the permission of the carer of the young person, but the system set up is because of that flag, if there's a new interaction with the police by a young person who's flagged in the system, then the FASD police officer will receive an email, so knows there's a new interaction, and then can look into that and see what needs to be done. It appears to be a very constructive response within the resources available in that community to the interaction of a young person affected by FASD in the criminal justice system. Now, I've briefly referred to the Key Worker program. That operates in various provinces in Canada, and essentially it is a skilled professional drawn from education or social sciences or perhaps the psychology field, who has this role to work with young people and their families to essentially over an extended period of time work with them to get a diagnosis and better understand the implications of that diagnosis, to negotiate with schools about accommodating the school program for the particular impairment of the young person, linking with other services in the community, everything from respite to structured recreation that might afford opportunities for the young person to develop social skills, social relationships that are positive and constructive rather than negative which often otherwise happens. That appears to be a very constructive response, recognising that a family is not able to deal with all of the behaviours and all of the issues that arise at the same time. And over a period of time, which may be years, needs the professional assistance of someone who can understand the diagnosis, understand the implications of it for the family, work with the family to accept and implement that, work towards the implementation of the recommendations, be a bridge, walk with them as they deal with the various agencies, to get the agencies to understand they have to accommodate the particular impairment. One of the problems with this disability is there's no one size fits all. The brain damage varies from individual to individual, both in terms of the nature of it, complexity and extent, which makes it all the more difficult. Now, one of the other programs, a youth justice program established in Winnipeg, sees a small team of 4, effectively community corrections officers, working with young people who are already in the system. They require that there's evidence of prenatal exposure, and they have a fairly blunt way of going about it. They described to me that their practice is to contact the carer, the biological mother. Of course, it's not always that, but in relation to the biological mother, asking directly over the phone whether she drank alcohol during the course of pregnancy. I was staggered by that because having talked to many from the health and medical field, there's a lot of reticence about asking biological mothers about their use of alcohol during pregnancy. Anyway, this team that I met with said that in years of this practice, so long as it is approached gently without judging, and it's put in the context of if your child has fetal alcohol spectrum disorder, we offer X service. But one of the criteria is whether the young person was exposed to alcohol. In a gentle, unjudging way, they assure me they have never had abuse down the line. On occasions, the woman doesn't tell them the truth or doesn't want to discuss it, which is entirely her right, and they respect that. But they also told me a tale of a young person who persuaded his mother to tell them that she had drunk during pregnancy because his mates were in this program and it was a good program. Anyway, of course, it came out later that she hadn't drunk within pregnancy, and so he wasn't part of the program. But in any event, this program starts when the young person enters the criminal justice system and there's either a diagnosis or there's a suspicion, and they do screening, they talk to the mother or carer, they get the child organised for a diagnosis if that hasn't happened. And then the first objective is to build a trusting relationship with the young person. Often, they told me, often these young people have difficulties with constructive social relationships. and are unused to an adult person who is interested in them and prepared to spend time with them. So they focus initially on developing the trust. Sometimes that's done through food and activities, and they're moving to do a bail report, to do a sentencing report that identifies a plan for how to work with a young person. If the ultimate sentence is custody, then they work with the young person whilst they're in custody on the issues identified in the pre-sentence report and prepare them for transitioning to the community. So it's an extended relationship. It's not 3 months or a few months. It's an extended relationship. Winnipeg also has a pilot project which is trying to get the alcohol and drug agencies to adjust their way of working to cater for FASD affected young people, because many of them have addictions issues, and Manitoba as a province sees that the alcohol and substance abuse agencies generally are unsuccessful in engaging this vulnerable population. Now, I wanted to turn to some themes that I see emerge from the most successful programs or places that are dealing with FASD in young people. Firstly, the importance of having an FASD strategy. I'm not simply talking about a strategy at a local level. I'm talking about a strategy at a state or provincial or national level that involves a detailed plan for how this challenge is going to be met in the community. Alberta, the province of Alberta, adopted a 10-year strategy 7 years ago, and it demonstrates how serious that community is about addressing the issue. It seems to have emerged from a combination of advocacy by adoptive parents and carers, and the science health community that had done a lot of research on the impact of alcohol on the brain. And also in Alberta they have an Institute of Health Economics that has undertaken research into the cost of doing nothing versus the cost of addressing the issue appropriately. So it adopted a strategy which was not focused simply on young people, but addressing FASD in the community across the lifespan, because of course it's brain damage. It doesn't stop when a young person reaches the magic age of majority, whether that's 17, 18 or 21. It continues for their lifetime. Now, Alberta and Manitoba have adopted these strategies. Economically, they've had quite different capacities to resource these strategies. So Alberta, until the pressure on the oil price, has had plenty of resources and put a lot of money into the FASD strategy, including trying to train and skill up its workforce, identifying different parts of the agencies across the board, whether it's social workers in care and protection, or it's the police or judges or frontline workers in various agencies. Over a number of years, training and more training has been rolled out. In the Department of Care and Protection, they developed very detailed and sophisticated training for their frontline workers to be able to identify early on with children coming into care the various issues, including FASD, with a focus on early diagnosis, early intervention. So the strategy involved leadership by government at a cross-ministry level. So collaboration is seen to be hard to do but essential to achieve. Also one of the important principles in Alberta's strategy has been not to reinvent the wheel, not to resource new agencies who are just focused on FASD, but rather to skill up existing agencies to deal with this population in an appropriate way. They divided the province into 12 regions. They resourced local FASD networks being established to bring together local providers and agencies, from the police to education, etc., to work out on the ground what they needed to do to get diagnosis happening, to get appropriate intervention happening. They recognised that systems needed to change if there was to be that collaboration across government and other agencies. And they recognise that the child has to be the centre. The child, the brain damaged child or adult, is not going to be able to change. Systems often have one way of delivering the service, and the consumer is expected to comply with the system's requirements. There's a recognition in Alberta that an FASD affected individual has to be at the centre. There has to be an approach by the agencies of focusing on the particular needs of that individual and adjusting their service delivery and collaboration so as to be able to deliver the service to the individual. Now in Manitoba, with less resources, they've done things like bring expert panels together in the education sphere. For example, in the primary and secondary area, to develop very detailed material for teachers who are faced with the challenge of trying to manage the behaviour and that comes with the often the FASD affected young person. These are invaluable materials which, if you're so inclined, you could access by going on to the Healthy Child Manitoba website. I've only touched on diagnosis and assessment, but that's absolutely vital. There's over 35 clinics in Canada, and that's not including mobile clinics, but assessment is absolutely vital, and it's recognised, at least in the Western provinces, that they don't have enough capacity, that it's absolutely vital if the young person is going to be able to access services relevant to their needs. There are two areas which stand out as being very significant problems, and that is managing support to young people who are leaving the care at law becoming adults, across the provinces, that meant in reality that whatever services they'd been able to access as a young person stopped the minute they turned 18. And so there's a lot of focus now on how do they assist those young people to transition through to the adult services. The second significant problem that seems to exist all over is having accommodation of various types, that is housing of various types for FASD affected youth and adults. Now, perhaps I've gone on too long, but can I just try briefly at the end to try to bring the human rights instruments that I've made brief reference to try to translate to some extent some of those obligations on states that have ratified them into questions for us as a community who are interested and committed to improving the outcomes for young people affected by FASD and improving community protection. So, for example, one of the questions is, are FASD affected youth receiving special care and support so that they can live full and independent lives? Are FASD affected children and youth receiving an education which is facilitating the development of each child's personality and talents to the full? And when decisions are being made with respect to children and youth who are FASD affected, is the best interests of the particular child the primary consideration? To the extent that systems, be they health, education, justice, care and protection, fail to make services available to FASD affected youth which address their needs in a timely manner, they are discriminating against youth with that disability, and the particular nation state is in breach of its international obligations under the treaty, and may be the subject of a complaint to the UN committee established by the relevant treaty to monitor compliance and receive complaints. And I'd remind you that signatories to international human rights instruments undertake to implement the obligations. And in this case, I'm referring particularly to the obligation to prohibit discrimination on the basis of disability and guarantee to persons with disabilities equal and effective legal protection against discrimination on all grounds. I've raised the international human rights standards so as to provide another argument in our kit bag when it comes to dealing with systems that are slow to respond to the needs of this vulnerable population, and governments that may be slow to adopt a comprehensive strategy and plan for tackling this issue and fail to resource an effective response while young people who are FASD affected suffer injustice. Okay, thank you.
Major problem is the diagnosis, it seems to me, because only, as I understand it, only 30% of FASD people have the facial features, which some have, and that leaves it to acknowledgement by the mother that alcohol was consumed during pregnancy, and with the reticence you've referred to, that can be a major issue.
Okay, I'm happy to answer that, but I would like to invite Dr. Valerie McGinn, who's a neurologist, to specifically address the point that you're making, if you would like to.
What we know with FASD is that the face is irrelevant to the disability, so a child's face is not anything to do with the disability. It's just that there is a point in time in gestation where the face is affected. So diagnosis of FASD is the same as diagnosis of any other disorder. There are recognised medical procedures that we undertake, and that diagnosis should be available to everyone. It is not unlike diagnosing autism or other disabilities, and we follow the Canadian guidelines to do that, and unfortunately in New Zealand we don't have any recognition of FASD as a disability or much diagnostic capacity, but it is extreme. I've diagnosed hundreds of children with FASD, and it is not difficult once that's your specialty field.
But I think the kernel of the point there is that most don't have the facial features. And so if I'm sitting in court and I'm in a busy list and I'm seeing a succession of young people, it would be a mistake for me to think that I'm going to spot it or see it, because mostly no one sees it physically. It's the brain function. That's the overwhelming majority of those that have FASD, which makes it, well, one of the aspects that make it so difficult in the justice system for us to deal with it.
And it's, once you're used to talking with women about alcohol, it's not actually difficult to get them to disclose alcohol consumption. But it is a process that requires sort of medical expertise as such. And we do have screening tools that could be used within the courts that will raise the likelihood, and currently most of our referrals that we get from the courts, there's red flags where judges or other people have seen, gosh, this is looking a bit like FASD, perhaps we need to investigate further.
Other questions? Yeah.
Whose responsibility is it? Which agency? Do you get diagnosed?
To raise it or to
get a diagnosis? Yeah.
Well, I mean, it's a health problem, so it should be available within the health system. But the thing is that it becomes the responsibility of whichever agency that person's presenting in. So if the person is presenting in the courts have provisions to order assessments to identify the needs of the young person so that they can be accommodated within the law. So in that case, the courts may order an assessment. If a child is young, they might come through the Child Development Service at the local hospital. They often come through the mental health services because their behaviours are difficult. Therefore, there is no particular one person who should be taking this on entirely on their own. I think it's something that needs to be spread across. The ideal, of course, would be if we had Child Development Services picking all of our children up when they're young, and then we wouldn't get them appearing as often in the courts. But I think they need to be recognised where they come up, whether it's a homeless person or it's a person with an addiction services. Or,
right.
Yeah.
Okay. I was told the Ministry of Education today was responsible.
Well, the Ministry of Education have got some responsibility for the education of the child, and so therefore they do have to adapt their procedures around a child's disability. So often the school is a very good place to pick it up. Absolutely.
They're not trained.
No, but we have educational psychologists that I train to do it. So I think everyone, it's everyone's problem. Yeah. It's everywhere. So everyone should be contributing. And I think there is a big. The schools are picking up a lot of behavioural problems and recognising FASD more, for sure.
We have one more question up the back.
You mentioned different ages of majority, obviously, in different countries, and ours is obviously 17, which is reasonably contentious. I was just wondering if you could speak to the relevance of that in the FASD stuff. Does it play a role, us sending our kids to jail?
I don't think the particular age plays a role, but it's a marker in each society of majority, maturity, adulthood, and it seems that many societies will have services for young people that will then stop, whether it's 17 or 18, and they will have a whole suite of other services or not for adults. And my perception is in this particular field, many have concentrated on getting diagnosis and services for young people for various reasons, and adults that may have FASD in large part have been ignored. But there are certain examples in North America where they've made a commitment to try to service that population as well. Whitehorse in the Yukon being one of them, and Alberta. They see it as across the lifespan there's got to be diagnosis and services, which really reflects the commitment to respect and inherent dignity of the individual.
On behalf of the audience, can I please ask you to extend your appreciation to what has been a very, very rich and interesting and detailed talk. So please show our thanks to Judge Crawford.